Gentlemen, when you're ready.
Thanks. Good morning. My name is Kevin McKeon. I'm a Pennsylvania construction lawyer with the law firm of Watt Tieder Hoffar Fitzgerald. I'm here today with two executives from two Pennsylvania construction companies, very prominent, Mark Reisinger of PKF Mark III and Jim Dacey of Doley Construction. We want to thank the committee for allowing us to offer testimony today on the most important safety legislation for our industry. We represent the National Utility Contractors Association of Pennsylvania. NUCA is a group of contractors, suppliers, and engineers dedicated to promoting the utility construction and excavation industry through safety, education, advocacy, and industry relationships. Our members work on water, sewer, gas, electric, and telecommunications projects, as well as treatment plants and site development. Importantly, the majority of these projects involve significant underground excavation and underground infrastructure work. Using heavy equipment, giant-sized Tonka toys might be a good way to visualize it, that are capable of digging and moving a massive amount of earth and material relatively quickly. As you know, this is dangerous work, not just because of the use of heavy equipment, but even more so because of what is concealed beneath the surface of the work site. And it's not just dangerous to the equipment operators and the laborers performing the work, but also to the consumers whose homes and businesses are tied into these power and gas lines in particular. The Underground Utility Line Protection Law that is before you for renewal should truly be referred to as the Utility Consumer and Utility Worker Protection Law, because for our members, it is truly about the protection of people, our own utility workers and the utility consumers, that is of the utmost importance as we review this law. Most people, however, refer to it simply as the One Call Act. On a daily basis, our members make calls to the One Call system to request the locations of underground facilities on their work sites, and they rely on the facility owners to comply with the One Call Act and to accurately mark their underground lines. Our members will tell you that the marks placed by the facility owners are as important to maintaining their life safety as are the red, yellow, and green lights of a traffic signal to all of us in safely commuting to and from work every day. Imagine the danger created by a malfunctioning traffic signal at a four-way intersection. But also imagine if you had no ability to see traffic coming from any direction. That scenario may give you some insight into why it is so important to us that facility owners accurately mark the locations of their facilities, particularly gas and power lines that are hidden underground and have the potential to cause disasters. Now, I personally have been involved with NUCA Pennsylvania for 20 years, while almost exclusively representing contractors in helping to manage and sort out the various disputes that arise in the construction industry. As a result, I often say that I feel that I am more a part of the construction industry than a part of the bar, although I'm a proud member of both. And those two worlds frequently collide at the One Call Act. That is why Brenda Regal, the Executive Director of NUCA PA, asked me to summarize the testimony on behalf of the association. Let me emphasize again, NUCA's primary concern, and all stakeholders' concern, and indeed the General Assembly's primary concern regarding the One Call Act is and should always be safety. All of our comments must be viewed through that perspective because our operators and our laborers are in the closest proximity to the danger zone. That being emphasized, our members would testify that One Call locates have gotten progressively worse, meaning that they have become less accurate. The picture included in our written testimony and on the cover of our written submission is just one example in which the actual location of a pressurized gas line is 6 feet from where the facility owner marked it. In that regard, our members would also testify that most underground facility owners are now subcontracting their locating services to third parties. These locators are not regulated, nor are they licensed. Most surprisingly, however, due to a legal loophole, the underground facility owners enjoy almost complete immunity, even when obviously negligent and creating a safety hazard as reflected in the picture. Brenda has included a wealth of materials in our written submission, and we respectfully ask you to review those materials in detail if you have not already. There's a lot of pictures in there. But we wanted to focus our testimony today on closing the loophole and holding all parties accountable, because no one should enjoy immunity when it comes to a safety issue. Let me take a moment to give you some context and background. In the situation shown in the picture, if the heavy equipment operator had hooked that gas line while excavating from the left to the right and caused an explosion that injured him or her and destroyed the equipment, there's no question that the facility owner, who is responsible for negligently marking that line, could be held liable for any and all damages. That's not the problem. The problem actually occurs when we have the same situation, but the operator gets lucky. No explosion occurs, no catastrophic injuries, no damage to the piece of equipment. Instead, imagine what happens when the operator merely breaks the line and safely evacuates the area. What happens next? Our members would testify that in that scenario, they must stand by and wait for the facility owner to come out and fix the break. Well, you might ask, what's so bad about that? No one got hurt. But in fact, the contractor is still hurt financially. Even on a small crew, we have several workers: equipment operator, laborers, a truck driver, a flagger, a foreman, or a superintendent. All of these employees stand by and wait, and they're entitled to be paid on an hourly basis plus fringe benefits. At the same time, we also have equipment, typically an excavator machine, a loader, and a dump truck, all of which are also standing by. But again, the contractor has to pay for this equipment on an hourly basis. In this situation, the contractor is paying between $600 and $2,000 an hour, depending on the size of the crew and the location of the site, for nothing, for no work, for no productivity, while waiting for the facility owner to fix the facility owner's mistake. Yes, luckily no one is personally injured, but the contractor is financially injured. Now, you would think that logically, if the contractor and its employees can recover against the negligent gas company when there's a massive explosion and a disaster, well, certainly they can recover these financial damages when, luckily for all involved, no explosion occurred. Unfortunately, this is wrong, and that is the problem. Under current Pennsylvania law, the economic loss doctrine prevents a contractor from holding the facility owner liable for financial damages, what you might think of as economic damages, unless someone is personally injured or property is damaged. Let me restate and rephrase that, because it may be hard to believe, and it's certainly counterintuitive. Unless someone is killed or physically injured, or there's a vehicle or a piece of equipment or a building damaged or destroyed, the facility owners cannot be held accountable. We know this because a few years ago, the Pennsylvania Supreme Court took a look at this precise issue in a case called Excavation Technologies versus Columbia Gas Company, and decided that the facility owner could not be held liable. This decision almost completely immunized negligent facility owners from liability absent a real catastrophe involving pain and suffering for physical injuries or property damage. Instead of recognizing a narrow exception to the economic loss doctrine, like courts in several other states, our court indicated that this was a matter of public policy best left to the Pennsylvania legislature, and that's why we're here. In our written submission, we have included a one-paragraph amendment to House Bill 284 that would simply hold negligent facility owners liable for financial damages for standby time when there is no catastrophe. The amendment is also reciprocal in that it recognized the facility owner's right to hold negligent contractors liable for the cost to repair broken lines as well. This amendment is patterned from a similar provision that's already on the books in New Jersey. I must point out that facility owners can already sue contractors for negligence, regardless of whether our amendment is adopted or not. The economic loss doctrine does not apply to bar their claim because the broken lines constitute property damage. Our members would testify that as a matter of practice, the facility owners will universally send the contractor a bill for the repairs and will sue the contractor because there is really no downside. This is where closing the loophole also levels the playing field. As the law currently stands, contractors cannot assert a counterclaim, again due to the economic loss doctrine. And earlier today, I think the representative from Columbia Gas mentioned that we could use the court system to sort out who's really at fault when these things happen. That's not the case in Pennsylvania because of the economic loss doctrine. Isn't it only fair, though, in a case when both parties allege negligence against each other, that either party can recover damages if they prove negligence? Of course it is. But in this situation, the best the contractor can hope for is to successfully defend itself. But the contractor will still incur thousands of dollars in attorney's fees to do so. As set forth in our written submission, we have also proposed a prevailing party attorney fee amendment to remedy this problem, and again, it's reciprocal. In conclusion, all stakeholders and this legislature must encourage a culture of safety in construction and further incentivize facility owners to accurately maintain and mark their underground lines. We're not generalizing, nor are we suggesting that all facility owners are marking poorly. Instead, we're simply asking that if we can prove that a facility owner has acted negligently, they should be held accountable regardless of whether there is a catastrophe or not. The way to make that happen, the way to encourage fairness and safety, is to adopt our proposed amendments to allow for recovery of standby time and prevailing party attorney's fees. Our proposed amendments are attached under exhibits to our written submission. Given the time limitations on our oral testimony, our written submission follows with a powerful memo from Mark Reisinger that expresses our opposition to any exemption for oil and gas gathering lines. And he recounts one example of a terrible accident that could have been prevented if the current version of the law did not allow for such an exemption. Also, as an industry frustrated with inequitable enforcement, no stakeholder advisory panel, and an unreasonable appeal process, our written submission also offers support for moving One Call Act enforcement to the Public Utility Commission. We appreciate your time and attention today, and Jim, Mark, and I remain available for any questions you might have. Thank you.
Just one question. It was in both bills, there was a damage prevention committee. Would that help Pennsylvania in any way, shape, or form?
We absolutely think it would. We think that it's important to have the stakeholders involved and have them have a say in the way these disputes get sorted out. But it will not solve the problem of a contractor being able to recover damages from a facility owner who's negligent.
If I can interject, Mr. Gottschall, the one-call bill is our lifeblood as ditch diggers of Pennsylvania. This one call, we make thousands of calls a year. We update them weekly, daily. We are constantly upgrading these bills. The one-call board is made up of 35 or 36 representatives of primarily utility companies, township, municipal authorities. We have one seat at that. We have one chair at that table representing the contractors. We hold our own. We're not asking, for any leniency. We hold our own, and for the most part, the one call listens to our issues. But as far as a damage committee, yes, we would feel we'd be more fairly represented with a seat at that table.
Thank you, Representative Nelson.
Thank you, Mr. Chairman, and thank you for your testimony today. Early in your testimony, you discussed the issue of third-party contractors and the decrease of quality that your industry has seen over the years in marking the lines. Do either one of your recommended amendments address the issue associated with poor location practices by third-party contractors?
Well, we believe they both do, because both amendments will further incentivize the facility owners to mark their lines accurately, because now they would know that if they don't, they could be held liable, even if they haven't killed someone or blown something up.
Thank you.
Thank you, gentlemen. I have no further questions. Just appreciate your testimony. Thank you.
Your time.